Hello and a good day to everyone. My name is Nia Salma, and today my group will be presenting on the ethical issues present when discussing confidentiality in the psychology field. Our team is made up of myself, Patricia Najla, as well as Carolina Shah. We will begin the presentation with me introducing the main concepts under confidentiality. First of all, it must be established that confidentiality, privileged communication, and privacy, although are all related in some sense, there are still important differences between them. As practitioners of mental health, we must familiarize ourselves with these concepts as well as the legal protection afforded to the privileged communications of clients and the limits of this protection. So according to Wheeler and Bertram, confidentiality is the ethical duty of a counselor to keep communications with clients private and is the core of effective therapy. Safeguarding clients from unauthorized disclosures of information given in the therapeutic relationship is the ethical and legal duty of mental health practitioners. Of course, there are limits to confidentiality, which we will dive into on later. Privileged communications, however, according to Knapp and Van de Kleek, is a legal concept that keeps confidential communications from being disclosed to judicial proceedings or court of law. This privilege, of course, belongs to the client. So if the client waives this privilege, the therapist must not withhold information. It's also important to note that privileged communication does not apply to group counseling, couples counseling, family therapy, or child and adolescent therapy. Now, privacy in legal terms refers to the matter of law where individuals have the right to control their personal information and be left alone, which is a constitutional right. It's the right to be protected from visibility, access, or intrusion by others. Invading a client's privacy can be unintentionally easy, which is why practitioners need to act with caution. The Jaffe versus Redmond case is the basis of privileged communication that the law recognizes, at least in the United States. The outcome of this case was that the Supreme Court ruled that communications between mental health professionals and their clients throughout treatment are privileged and therefore protected from forced disclosure. Next, we will talk about confidentiality and privacy in a school setting. We've all heard of the counselor back in school who would share confidential information regarding their clients to other teachers, which is, now we know, is highly unethical. School counselors have the responsibility to serve the students, the parents or guardians of those students, and the school system in which they work for. And they must be ethically and legally balanced. The privacy of underage clients still need to be respected, and confidentiality must be maintained. However, this might conflict with parental rights to be informed about their children's treatment. While minors expecting confidentiality is an ethical right, parents requesting information regarding the counseling session is also a legal right. Confidentiality and privileged communication belong solely to the client, so they have the option to not partake in counseling if there is reason to believe their session is not held privately. Only when there is transparency on whom, when, and how information about the sessions is exchanged, then can counselors have a trusting relationship with their client. Of course, as mentioned earlier, there are exceptions to confidentiality and privileged communication. On the screen here I'm showing are the exceptional circumstances in which information regarding counseling sessions may be shared with others in order to provide the client with competent services. Exceptions to confidentiality and privileged communication also exist when they are legally mandated. Those exceptions are listed as on the screen. The legal exceptions are created from sometimes preceding case laws, such as the Tarasoff versus Regents of the University of California. The court's ruling requires that therapists breach confidentiality in cases where the general welfare and safety of others is involved. Because this was a California case, courts in other states are not bound to decide a similar case in the same way. For instance, in Texas, mental health practitioners are relieved of the duty to warn and to protect victims through breach of confidentiality, which was ruled by their court under the Tapper versus Zazulka case. That is all from me. Now the presentation will proceed with Caroline. Thank you.
Hello, my name is Caroline Asha. Next, we will see privacy issues with telecommunication device. In this digital world, we can see that digital technology is considered to be necessity in today's world, and also it's not keep out in the helping professions. According to RIMA 2016, he stated that all electronic instruments such as computer, tablet, email, and all kinds of instruments, it is also used to deliver service and communicate with clients and also manage confidentiality case records about client. Other than that, as stated by Suit 2013, the possibility of problems regarding client confidentiality, privacy, all paperwork documents, and boundary issues between counselor and client also need to take as an important, serious matter. Other than that, Brummel and Joshi stated that the measure taken to protect confidentiality can include secure password encryption between counselor and client. Although those extra steps could not guarantee complete confidentiality between counselor and client. The telephone might be the most preferred method of counseling in face-to-face session if unable to perform. Counseling, however, more research is required to decide who is most likely to benefit from telephone therapy and in what circumstance. That being said that most counselors need practice awareness in discussing confidentiality information with anyone using mobile phones and mainly when recurred to digital technologies. Next, the duty to warn and to protect. This can be stated that professionals of mental health informed by courts become aware of their dual responsibility of protecting others from unsafe clients and protecting the client from themselves. Next, the duty to protect potential victims. Many risk professionals are not legally responsible to make wrong prediction of client aggressive behavior. These are failure evaluation of a therapist's risk to a client can lead to responsibility for the counselor. Although the prediction of violence alone may be a worthless approach in decreasing cruelty, as stated by Mosman 2009. And also, almost every jurisdiction has different opinion regarding the responsibility to protect and warn. For example, some not having a law regulation regarding the issues and some with official guidelines with a specific rules. Most stated allow breach of confidentiality for warning of or protecting victims. However, some states that relieve mental health practitioner of those duties. For example, the practitioner of mental health Dapar versus Zizulka are willing to protect and warn their clients and their specifically intent victims which was proceeded over by the Texas Supreme Court. Next, we will see the duty to protect potential victim. There are two different duties in this study. We can see that duty to warn and duty to protect. First, we can see the duty to warn, which is mental health practitioner must make a decent attempt in contacting or reporting the law to in enforcement of the danger the identified victim of serious threat to the clients. Next is duty to protect, which is stated like mental health practitioner must protect the threatened third party which offer more option other than simple warning them. This also provide protection of client confidentiality since the duty to receive essential information require confidentiality details disclosed within the third parties. In some cases, they are warning the involved third party might not be the best option. Better suited action, which include taking care of the client and also increasing density of the therapy to client session and which informing the police officer, and also referring the client to consult a psychiatrist or prescribe medication. It is stated by Demers or Siegel in 2016. Next, we will see ramification of duty to warn and to protect for school counselor. It is stated that school staff or school administration, they may have to follow up on students' reports of their colleagues' arrangement identify with proposed behavior or violence. Furthermore, the school authorities may be considered responsible if any students composing task contents of proof of behavior in violence. The school counselor are lawfully and ethically committed to pursue forestalling school violence, as stated in Herman and Finn in 2002. Meyer and co-author 2005 stated that the ethics code are given no clarification concerning what conceivably problematic or harm behavior, and individual school counsel are probably going to elucidate this in an unexpected way. This can be reliable discover the school counselor have an obligation, practice sensible constant to shield students from predictable danger. A school counselor attempts to give a protected spot to students to uncover their own issue. However, these counselors additionally have an announcing obligation in numerous cases in their students, from their students. As Meyer and colleague 2012 stated that review school counselor to get the impression of when it is ethical to educate executives about their dangerous students' behavior. In their research, the counselor is more ethical and consider breaking their confidentiality when the counselor notices that any risk-taking behavior of students that might be taking the school counselor or mental health professional, they need to take an immediate action when they do occur to the students. The school counselor also should not be set up or lead to accept any obligation that might be past the extent of their proper training. This can state that they react to the requirement and requests of students, staff, and manager and receive various jobs which may instruct job clashes. Now, the next we will see the duty to secure suicidal clients. In these cases, the many clients dies by suicide. The danger of unethical behavior activity is significantly decreased if the counselor can show that the sensible appraisal that medicated measure occur. For example, professional counselor was looked for, clinical reference were made when necessary, and current document which was finalized. As Rimley and Hadley 2016 stated that counselor can be blamed for unethical behavior to fail make a move to prevent damage or hurt when a client is probably going to make the steps of suicidal, which is they are obligated in the event that they overcompensate by making move that abuse a client's security when there is certainly not a reasonably reason for doing as such. And also, in the event that a counselor makes an assurance that a client is in a danger for suicide or any harm for suicide, the counselor should make an immediate important step to prevent the damage to the clients.
Hello, I'm Batrisha Najla. Today I will present about ethical issues in accepting and treating non-suicidal self-injury. It is a mistake to assume that most people who self-injure are suicidal just because suicidal people usually harm themselves by self-injure themselves. However, counselors who work with clients who self-injure will most likely deal with ethical dilemmas regarding safety and duty to warn or protect. Non-suicidal injury is a complex and often misunderstood issue that may require counselors to re-evaluate their assumptions and biases before providing safe and effective treatment. By Wiesenhans, Stagger, and Pagesi. School counselor liability for student suicide. According to Capuzzi and Gross, school counselors are expected to be aware of the warning signs of suicidal behavior and need to have the skills necessary to assess a student's risk for suicide. Capuzzi also stated, to manage the regular risks associated with their jobs, school counselors must be prepared to determine whether a student may be at risk for suicide. Evans and Horace made a systematic review of qualitative research on the role schools play in children's self-harm and suicide found that only the most severe forms of self-harm are defined as such by school personnel. This issue is compounded by structural barriers such as the limited time staff have to spend with individuals, which reduce opportunities for detection and disclosure. School counselors who do not possess competency in identifying and managing students who may be suicidal need supervision, consultation and direction from counselors who possess such expertise, according to Remley. Although school counselors are not expected to predict all suicide gestures or attempts, they are expected to use sound judgment in making clinical decisions, and their reasoning should be documented in their notes. In cases where school counselors make an assessment that a student is at risk for suicide, it is imperative that the student's parent or guardians be notified that such an assessment took place. Parents or guardians have a legal right to know when their child may be in danger. How to protecting children, elderly and dependent adults from harm. Mental health practitioners are ethically and legally obligated to prevent abuse and neglect towards children, older adults, and dependent adults. In this case, confidentiality cannot be applied and constitute a situation of reportable abuse. Mandatory reporting is intended to ensure the reporting of suspected child, adult, or adult abuse cases. It is recommended that under uncertain circumstances, the therapist to err on the side of reporting. Confidentiality and HIV or AIDS related issues. Most mental health practitioners eventually come into contact with people with AIDS. Those who have tested positive as virus carriers or those close to this individual. These customers are often discriminated against, so professionals must respect their situation, obtain informed consent, and educate them about their rights and responsibilities. You might accept and establish a therapeutic relationship with client that you would later find out that this person had been tested positive for HIV. If this were the case, how would you answer the questions below? Below are some of the questions that you will face. Ethical and legal consideration in AIDS-related case. There is still no landmark case to determine a precedent of a therapist's legal duty to protect other people in a HIV-positive client's life. Careful consideration should be given to breaching confidentiality due to the danger to others posed by HIV-positive clients. The following recommendation for therapists can help in making this decision. All limits to confidentiality should be discussed with the client at the onset of treatment. Therapists need to keep current with regard to relevant medical information related to transmission of HIV, know which sexual practices are safer and which are not, and encourage their clients to practice safer sex. Therapists should speak directly and openly with their clients about their concern regarding the danger of certain behaviors and the risk to third parties. If the client continues to resist using safer sex practice or refuses to inform partners, then the therapist needs to determine what course of action to follow. In disclosing HIV information, therapists need to follow the statutory guidelines and safeguard the client's privacy as much as possible. So to conclude all of this, mental health practitioners are responsible to fulfill their duties to their clients, their agency, their profession, the clients' families, and to themselves. Ethically concerning confidentiality is only an issue when those responsibilities conflict one another. So that's all from all of us, and we will proceed to our discussion.
Our discussion today will consist of us giving our opinion on this special case of Lorenzo. The first question is, what is your general impression of the way Lorenzo's counselor handled the case?
In my opinion, throughout the session, Lorenzo counselor did not break the counselor assessment by handling the counselor session in confidentiality.
In my opinion, the counselor did a decent job by wanting to talk with her colleague about this case, but at the same time, she failed about this case because one, she doesn't want to continue the counseling session with him unless he stopped using drugs. It feels like she forced him to quit using drugs. Second, she needs to breach the confidentiality by informing his parents to, by informing his parents too, because there's no guarantee that he will stop using drugs. Thus, he's being harm to himself and anyone else too.
Okay, for the next question, do you think the counselor act in a responsibility way toward the client, the parents, the agency?
Yeah. As I said before, the counselor didn't really being responsible by not wanting to continue the counseling session unless he stops using drugs and informing his parents about his still uses drugs. The parents did a right thing by filing a suit against the counselor and agency.
To me, yes, I think she was irresponsible towards both the client and his parents. Because even though Lorenzo had already confided in her that he's had a few brushes with death, she still failed to take any actions necessary to stop him from further causing harm to himself. So Lorenzo's case is clearly proof that he was a danger to himself and others. So legally speaking, confidentiality between them can be breached.
Okay. So, if you were convinced that Lorenzo was likely to hurt himself or others because of his drug use and his emotional instability, would you have informed his parents even at the risk of losing Lorenzo as client? Why or why not?
Okay, in this
First,
case,
oh,
if I
sorry.
get to know that Lorenzo have been involving in violence behavior and instability emotion, as a counselor, I will break the counselor assessment where I will inform his parents about his situation to keep eye on him. It is because as a counselor, there are many circumstances and legitimate which disclosure of confidentiality information to both official agency, parents, and or legal guardian.
Well, personally, I wouldn't inform his parents, but I would take extra precautions in treating Lorenzo. For example, after learning about his drug abuse problem, I would have referred him to a psychiatrist or someone with that sort of credential to treat his addiction. And because I've already spoken with his parents before, they should be able to fully trust about why I had to take such measures without them questioning me in detail.
I see.
Okay, so the next question is, state the legal limits on you as a therapist during the initial session.
For me, based on knowledge base, this client seeks counseling to recover from the drug abuse. His therapist has no particular expertise in working with this field, so that therapy has the duty to refer the client to a more qualified provider, because therapy should try to gain expertise in the area that the client may be facing by conducting research, consulting with colleagues, or attending training. If this effort do not provide adequate results, that counsellor has the duty to refer the client to someone with the right skill set.
Okay, well, in my opinion, the legal limits that are protect to protect therapist confidentiality that will help establish and maintain trust with client. and also notify clients about the privacy rules also. Okay, for the number 5th question, will you consult with the supervisor at the agency as well as the other colleagues?
Yes, I will consult with my supervisor or my other colleagues, because if I'm new into I'm still new into this field, as I'm still not have enough experience about this case. I will consult with my supervisor and our other colleagues to have them to have them give their opinions to me.
I agree with Patricia. I would also ask them as consultation with peers or experts, which is included in the exceptions to confidentiality and privileged communication. But I would still ask Lorenzo's permission first, if I had not already mentioned it in the informed consent that I would need to consult with other professionals.
Okay. So, would you refer Lorenzo for psychological testing to determine the degree of his emotional disturbance?
I would definitely send Lorenzo to be tested because I personally am, as a counselor, am unfit to assess his emotional disturbance. So, in addition, I would also be able to incorporate the results of the test into my treatment plan for Lorenzo.
I definitely agree with Mia. Yes, because it will help to know the level of his emotion to continue the session.
Okay, the next question. Would you refer Lorenzo to a psychiatrist for treatment?
I will recommend Lorenzo to psychiatrist treatment because he is not affected by emotion but also physically.
Okay. Because in psychiatrist field, we have an psychiatrist. Addiction psychiatrists specialize in diagnosis and treatment of substance abuse and the mental health condition that accompany it. Addiction psychiatrists treat people of all ages who have addiction to illegal drugs, alcohol, and prescription medication, complicated by coexisting mental health disorders such as depression, bipolar disorder, or schizophrenia.
Okay, for the next question, do you continue to see Lorenzo without any stipulations?
Um, in my opinion, I would not continue to see Lorenzo if there is no further discussion between us about his drug problems or our confidentiality. Only if there's mutual understanding between the two of us regarding these two aspects, then would I continue our counseling sessions.
Okay, for me, I will still see Lorenzo without any stipulation, because each client should be accepted and valued for who they are, as they are, without stipulation, because clients need not fear judgment or rejection. That is my opinion. Okay, so next question. What potential ethical violation do you see in this case?
Um, what I see in this case is that because Lorenzo is a minor, the counselor herself should have spoken to both Lorenzo and his parents when explaining the informed consent so that all parties fully understand confidentiality between the counselor and client as well as the limits of confidentiality. And personally, I think the counselor failed to do so when she only spoke about confidentiality with Lorenzo's parents instead of all of them together.
Yeah, I
Yes.
agree with Mia. Because the potential ethical violation that I see in this case, the Lorenzo counselor know the limit of confidentiality throughout the session, and also she has been used the informed consent right to Lorenzo parents before the session has been started to Lorenzo.
I see. Okay.